Hey everyone, when you first look at something like the law, it can seem like, well, just a total mess, right? Like a bunch of chaotic notes. But what if I told you there's actually a really clear logic hidden inside? Today, we're going to dive into the Indian Penal Code, and together, we're going to find that logic and turn this jumble into a crystal clear picture. You ready? Let's do it. Okay, so let's kick things off with a question that honestly trips a lot of people up. What is the real legal difference between theft, robbery, and dacoity? I mean, we hear these words all the time, sometimes used for the same thing, but in the eyes of the law, they are worlds apart. And figuring out this puzzle, that's our first step to seeing how the whole code is built. All right, so to crack that question, we've got to start at the beginning with the foundational category, offenses against property. Think of it like this. We're going to start with the simplest, most basic crime in this group. And then we're going to see how the law adds these little ingredients to build it up into something way, way more serious. And here it is, our foundational block, our starting point, theft, covered under Section 378. For something to legally be called theft, you need three key ingredients. First, there has to be dishonest intent. You're not just borrowing it. Second, it has to be movable property. Something you can actually pick up and take. And third, and this is crucial, it's got to be done without consent. Simple, right? This is our baseline. Okay, you've got our baseline. Now let's start cooking. Let's add our first new ingredient into the mix, fear. What happens when you're not just taking something, but you're making someone hand it over because you've put them in fear of injury? Well, the whole recipe changes. Under Section 383, that is no longer theft, it's extortion. And remember this one, because both theft and extortion can become the base for our next crime. All right, time to level up again, and this is where things get really interesting, because the law is super specific about timing. If in the middle of committing either a theft or an extortion, the offender uses or even just threatens instant violence, boom, the crime escalates dramatically. That sense of right here, right now danger is the absolute critical ingredient that transforms it into robbery under Section 390. So you might be asking, how can you make robbery even more serious? Well, believe it or not, the final ingredient is just a number, the number 5. Because when 5 or more people team up to commit or even just attempt a robbery, the law gives it a whole new name, dacoity, under Section 391. And that is the top of this particular chain. And look at this. This table just lays it all out perfectly, doesn't it? You can see the whole logical staircase we just climbed. We start with the basic dishonest taking of theft. Then we add the ingredient of fear, and it becomes extortion. Then, to either of those, we add instant violence, and it's robbery. And finally, the last ingredient, get a group of 5 or more people together, and it escalates to dacoity. It's not random at all. It's a clear step-by-step logic, built one ingredient at a time. Okay, so we've got the logic for property crimes down. Now let's see if we can apply that same key ingredients thinking to a totally different category, offenses against the body. Here, our focus is going to shift away from property and onto two really crucial ideas, physical control and consent. You'll see how the law makes these really fine distinctions based on the degree of control and the quality of consent. And here's a perfect example of what I mean by fine distinctions. On one hand, you have wrongful restraint under Section 339. That just means you're blocking someone from going in a specific direction they have a right to go. But then you have wrongful confinement under Section 340, which is much more serious. That's when you prevent someone from moving at all beyond certain boundaries. Think about it. It's the difference between finding a road blocked and being locked in a room. Huge difference, right? The law also gets incredibly specific about the method of harm. It's not just about what you did, but how you did it. Take Section 326A, for example. This was created specifically to address the horror of acid attacks. In this case, the unique ingredient is the acid itself. You combine that with the intent to cause permanent, horrific damage, and the law defines it as its own uniquely grievous crime. It's a powerful example of how the law has to evolve to name and punish new forms of violence. And we see this same specific ingredient-based approach when the law addresses sexual offenses. It doesn't just have one big, broad rule. Instead, it carefully defines distinct violations. It starts with physical boundaries in 354A, which is about unwelcome contact. From there, it can escalate to more forceful acts, like an assault with the intent to disrobe in 354B. But the law goes further. It also protects our privacy. making voyeurism a crime in 354C. And finally, in 354D, it addresses that persistent psychological harm of stalking. You see, each section is targeting a very specific kind of violation. So, with all these different offenses, what's the one crucial ingredient that underpins everything? It's consent. And let me be clear, under Section 375, the law is absolutely unequivocal about this. An act is a crime if it's done without clear consent, period. It's also a crime if that consent was gotten through fear or lies or any kind of fraud. This concept, it isn't just important, it is the absolute bedrock of all these laws. So far, we've mostly talked about crimes that might happen between strangers, out on the street. But the law doesn't stop at the front door. It also looks inside the home to address the very specific and terrible kinds of harm that can happen within family relationships. It acknowledges that the home can be a space of unique vulnerability. And this is maybe nowhere more powerfully illustrated than in Section 498A, which defines cruelty by a husband or his relatives. Listen to how the law defines this. It looks beyond just physical violence to include, and I'm quoting here, any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health. That was an absolutely vital addition to the code because it recognized and gave a name to the deep, devastating harm of domestic abuse. Okay, we've covered a lot of ground. We've looked at property crimes, crimes against the body, and even crimes inside relationships. So now, let's do what we set out to do. Let's zoom out, tie all these threads together, and see the big picture, the simple, elegant logic that connects everything. Because when you look past all the section numbers and the legal jargon, you realize something amazing. The Indian Penal Code isn't just some random list of rules and punishments. It's a system built on 3 core pillars: intent, force, and consent. Was there dishonest intent? What was the level of force involved? And most importantly, was there free and willing consent? By asking these 3 simple questions, you can understand why theft is different from robbery and why a consensual act is the polar opposite of an assault. This is the logic that turns all that chaos into absolute clarity. And that brings us to a final, really important thought. The law isn't set in stone. It's a living thing. Sections on things like acid attacks and domestic cruelty were added because society recognized a profound need for them. So that leaves a question for us, for you. As our society keeps evolving, especially with things like the internet and AI, which of these legal definitions do you think will need to change next? What new ingredients will the law have to start considering to keep up? Something to think about.